So I'd like to welcome you to the climate change panel. We have three diverse perspectives to provide you this afternoon. First, we'll have Travis Allen. Travis is partner at Zizzo Allen Professional Corporation, where he advises public and private sector clients on environmental matters with a focus on climate change. He particularly provides his clients with perspectives on municipal liability resulting from climate change, greenhouse gas reporting obligations, and policy. Travis serves on several boards, including acting as co-chair of the Climate Change Lawyers Network. He'll be speaking to us about greenhouse gas emissions, disclosure of climate change risks, as well as providing us with the municipality's perspective. Jean Piette is senior partner and chair of the environmental law team at Norton Rose. He was the first lawyer in Quebec to develop a practice entirely devoted to environmental law. He's extensive experience with both environmental law and development of environmental policy. He provides strategic advice on an extensive list of matters, including permitting, auditing, and environmental due diligence. Jean will be providing us with an overview of Quebec's climate change policy and the effects of the cap-and-trade system. Sophie Thériault is a lawyer and associate professor here at the University of Ottawa in the civil law section. She clerked for the Honourable Louis Lebel before earning her LLD at Laval University. Her recent research projects focus on Inuit food security and environmental justice, as well as the duty to accommodate and consult. Sophie also contributed to the multidisciplinary book entitled Local Climate Change Law, edited by Ben Richardson. Sophie will speak to issues related to Indigenous peoples' governance of climate change in Canada. She will compare the situation of Indigenous communities governed by the Indian Act and those that are parties to self-government agreements. So welcome to the panel members, and we'll have Travis start off.
Is there a clicker I can use?
Oh.
Is this, oh, great, okay. So I'm notorious for going over my time, and I'm going to set a timer right now so that I let our other speakers have a chance to speak. So first off, I would really like to thank you for having me here today. I'm really, really excited by what CAILS is doing. The energy here is great, and it's really exciting as someone who graduated not very long ago to see so many environmental law students or students with this interest from around Canada here. So big congrats to the conference organizers, Mark and Lindsay and your team, because I know it must have been a big job. So I'm Travis, and I'm here today to talk to you a little bit about climate change law in Canada. And I thought about doing an overview of law and policy across Canada, but I decided that what I would rather focus on is how climate change may affect your practice as future lawyers or as current lawyers in ways that you may not have thought about yet. So I am going to assume a bit of knowledge on your parts about Climate Change 101 and basics, and just dive right into some areas that I think are particularly interesting. So I'm going to talk about floods, beer, and data. And if you remember this talk as the floods, beer, and data talk, that is totally okay with me. Because I think sometimes it's helpful not to think law first, but to think practice first, to think of the issues that your clients may have. And when I use the word clients, I recognize that some of you may work for governments and some of you may work for in-house for companies, and there's a whole bunch of different types of practices, but rest assured I mean all of those clients that you work for. So just one thing I wanted to clarify, because I might use some jargon, and I hate when people don't clarify the jargon. Adaptation, when we say that, what we mean is very basically adapting to the changes in climate that are predicted to occur. So an example of that in a sentence is our municipality is adapting to predicted higher summer temperatures by planting trees so that it's more comfortable and safer for people to walk in the summer. And then a mitigation is when we reduce our contribution to greenhouse gas emissions in the atmosphere. So an example of that in a sentence is we are mitigating our effect on climate change by switching from a car to riding a bike once a week. And you'll see that the two circles overlap, and that is because some actions can have both a mitigation outcome and also an adaptation outcome. So urban forestry that I mentioned can also sequester carbon. Sorry. So let's start with floods and water disasters. This is a picture of the Finch washout from 2005 in Toronto. It led to an estimated $500 million in insurance claims. There were some big pipes and cables running under this road, and when a lot of groundwater and subsurface water rushed through into this area that maybe was not drained in an appropriate way, it led the road to wash out and destroyed some pretty expensive infrastructure, it turned out. And I'm putting this up there because I would like you to have an image for some of the adaptation issues that I'm going to be talking about. So I'll just put a couple up there. These are some things that climatologists and people who know a lot more than me about science tell us that we can predict in various parts of Canada. It's just a couple example points. The one that I'm going to focus on a lot is increasing precipitation and increased intensity of storms. So, you know, when we talk about storms, we can talk about how much rain falls and over how much time, because that will impact how the water is actually taken into our stormwater management systems. Okay? So, but there's many other adaptation concerns, of course. So when we look at these, what do we see? Well, the thing that I think about is damage to people and property. So when we have more frequent, more intense storms, when we have a lot of water falling in a very short period of time, that should be triggering some alarm bells because our infrastructure as it is built today may not be ready to handle that. And so we might get situations such as the Finch washout that I showed earlier. And so when we hear damage to people and property, the law of torts, which some of you may be studying now, some of you may have studied recently or not so recently, comes into mind. And it comes into mind because some of our clients may own large factories, they may own large pieces of infrastructure, they may be responsible for dealing with water as it flows across the land. And there is the potential that more frequent, more intense storms will actually cause serious damage to infrastructure. I'm going to be giving some examples, not just the Finch example I gave earlier, to make that more concrete. So, you know, we have, and I am not an expert on tort law, so I do more transactional work, but this is an area that we talk about a lot at our firm. You've got some issues relating to negligence, which you probably studied more recently than I did. But what I want to really focus on is what you do with climate change information. So I want you to put yourself in the position of a municipality that is responsible for dealing with stormwater. And let's talk about, say you have a new area of your municipality that you need to service. So you go to your engineers and you say to your engineers, okay, well, we need to put in some pipes. How big should these pipes be? And the engineers will say, well, based on our previous experience, based on all of these different factors and codes of practice, we use this thing called the 100-year flood. That is like the worst flood that we can imagine happening in the past 100 years. And so we'll build a pipe that should accommodate that flood. And the idea here is that you're trying to keep people safe, you're trying to make your stormwater management system work really well. But what happens if that process, that backward-looking process, is actually not reasonable anymore? So, for example, what if you have a university nearby that is predicting that your 100-year flood is going to become your 50-year flood or your 30-year flood because of some of the issues relating to climate change, such as more frequent, more intense storms? How do you deal with that in your municipal decision-making system? How do your engineers deal with that issue? Now, this might seem like a weird topic for a lawyer, because none of us here are engineers, presumably, or not many of us, but we think it's really important because it could impact a municipality's liability when it's building or maintaining its facilities. And we also think that it could be important for private companies that own large facilities that could potentially be damaged because of climate change, or could result in harm to people or property. So who could be sort of implicated in this type of decision making? There's a couple of different people, but your owner or occupier of land, government entities, and engineers and contractors. So how would this play out in real life? Well, I would like to draw your attention to two cities that are currently facing some pretty serious class action lawsuits in Ontario. And I apologize for being kind of Ontario-centric, but here we are, right? So there is, well, there are two class action suits that have been filed up in Thunder Bay. So I've put their combined 800 million because there's actually two different law firms competing to be the class that represents these plaintiffs whose basements and properties were damaged because of a large flood that caused the city's water treatment plant to overflow. And then in the city of Mississauga, we have one which is Panza, and it's for $200 million. It's relating to the Lisker flood area in that municipality. So in both of these cases, what we see is a municipality being sued, and the plaintiffs are alleging negligence because of many different things, but a lot of it has to do with the design and maintenance of stormwater, wastewater treatment facilities. So in both of these cases, we had like a large sudden rainstorm. In Thunder Bays, which I know a little bit more about, there had been a couple days of very intense rain, and then there was one day with a lot of rain. I think that was March 26th. So anyway, the plaintiffs in that case are really going to be arguing, well, they do argue, and this is at a very preliminary stage, I should point out. This is not a, we don't have a decision. They're still trying to see whether they can certify a class. They're saying the municipality of Thunder Bay and its professionals and engineers totally should have expected the amount of rainfall that occurred. It was very foreseeable. It was consistent with the past history in Thunder Bay. And they even had warning because the storm was moving up from the United States. Now, presumably the city of Thunder Bay is going to say, no way. This was a totally insane, very intense period of rainfall. There's no way we could have been predicted to design for this. It would be so costly to design for the 500-year flood scenario. And we'll see how that plays out. Like, I can't tell you how this decision is going to go, but what it makes me wonder, and what I would like to sort of hope that everyone here will wonder about a little bit, is how do we deal with those kinds of issues when we not only have now historical data to look at, but also better, more granular, more helpful modeling from universities, from climatologists, from people who are trying to predict where our climate will be going on a more regional scale. And I mean, I've just put up some points here about class actions. They're really exciting. They increase access to justice. They reduce the cost. I mean, if it's just your basement, maybe you wouldn't go after a municipality on your own, depending on how much money you have. In Thunder Bay, these people tend to be fairly low income around the water treatment facility. But as a class, you're more powerful, and there's an opportunity to go after justice. On the other hand, if you represent a municipality or a company, well, that's a big concern that we're seeing an increased number of classes. And in McLaren and Stratford, and I think it was 2005, we had a successfully certified class in relation to a flooding claim. So that's just something to watch. And the question is, so I should point out, these cases here don't talk about climate change. They just talk about flooding and rain and things like that. The interesting question for me is, will we start to see sort of very industrious plaintiffs' attorneys actually bringing the climate science into future flooding cases and saying, not only was this not negligent based on past experience, but you should have also listened to the university, and that was also negligent. So really cutting edge issues here, and I just thought I'd throw that out there in case you end up going into litigation. Okay, because my time is running fairly short, I'm going to switch to beer. Could you put up your hand if you will be finishing off this conference with a refreshing bottle of beer? Okay. And could you put up your hand if, in fact, you were choosing a can for environmental reasons? Okay, good. So, Mountain Crest Brewing Company made a televised claim that beer cans are better for the environment than glass beer bottles. Ergo, you should buy this beer, which comes in cans. So that claim was actually the subject of an advertising standards complaint. They had, the complainant claimed that it was misleading, and the Advertising Standards Council gave a really interesting decision relating to this beer claim. They said, this was not backed up by sufficient scientific information, it was misleading, and it was too general. Now, you might not have thought you were going to hear about marketing law at an environmental law conference, but what I want to flag for you is that actually understanding environmental issues and understanding climate change can be very helpful if you do end up working in-house at a company that sells consumer products. Because oftentimes these companies will be making claims relating to environmental attributes, and it is not, it's unbelievable some of the claims that actually slip through review, and I think part of it is because of lawyers who aren't really apprised of how careful we have to be about environmental claims. So here are just some examples of guidance that you can turn to. They're very readable. This is kind of a really cool area of law. The Advertising Standards Council has some great stuff, and the Competition Bureau talking about how to deal with environmental claims. And I put some tips up. So the big one I want to focus on is implying a scientific basis when you do not have one. This happens all the time. So companies will come up with something that they think is a really good idea from an environmental perspective. Lululemon actually was selling pants for a while that had seaweed woven into their thread, on the sort of basis that that would make these great skin benefits that would be so vitalizing or revitalizing. Anyway, no scientific basis, and ended up being the subject of some pretty embarrassing complaints and media coverage. And I just use that as an example to say that, you know, maybe you go in-house to a company. These are the questions that you can really use to help your client and to distinguish yourself, because you understand the scientific background and how ridiculous some of these claims might be. Okay, am I over time? Yes, wrap it up, Travis. Okay, okay. I just want to flag an issue that comes up in my practice a lot. Privacy. Privacy is important because we now are rolling out smart meters across Ontario and much of Canada. They are so exciting. They are helping people reduce their electricity consumption and helping charge in different ways at different times, depending on the price of electricity. That has huge climate change benefits, and understanding that can help you help your clients. But the problem is, can we do this without completely betraying people's trust? Because data is a very important commodity. It can reveal a lot about people, and inappropriately sharing it can put your customers at risk. So what I find as an interesting aspect of my job is trying to help balance the environmental goals with some of the other areas of law that we need to interact with, such as rules around privacy in Canada. And I'm just throwing up some sources that you may want to look at. It's not all of them, and these are sort of Ontario focused, but later if you want to look at these and get a start. And I put up some keywords from the Privacy by Design principles created by Dr. Anne Cavoukian, who's the Information and Privacy Commissioner of Ontario. She's great, these are great. A big thing to watch out for is when companies have put a privacy policy on their website and they stole it from another company, and it's not adequately adapted to what they're doing. And this also comes up for environmental NGOs, because a lot of them are starting to help people collect data and reduce their energy consumption as well. So I'm just putting up my pictures again because I liked the Microsoft Word clip art that I used, and because I really want to emphasize the idea that if you want to get engaged in climate issues or environmental issues more broadly, you don't need to call yourself a climate law firm and start a weird boutique practice in Toronto like we did. You can and should be bringing these questions and your scientific curiosity into every type of practice, whether for a large firm or a company or an NGO, because it's going to be relevant and you will be valued for asking these questions. So thank you very much for having me.
Thank you, Travis. So up next we have Jean, who's going to speak about Quebec's climate change policy.
So good afternoon, everyone. My purpose this afternoon is to give you a description of what's happening at a provincial level in Canada with respect to climate change policy. I'm taking Quebec as an example because that's a jurisdiction where I live and work. So I hope to provide you with a good oversight of what is Quebec's climate change policy, which embodies a quite aggressive and audacious cap and trade system. So Quebec has adopted a climate change policy that was adopted by the government. It takes the form of an ambitious climate change action plan for years 2009-2020. The plan was actually adopted by the previous government in 2009. What's interesting is that this plan enjoys considerable support from the civil society, despite some reservations that were expressed by industry, that it is too ambitious, and despite reservations expressed by NGOs that it should be more aggressive. The action plan actually will affect industry, especially the oil and gas industry, but hopes to neutralize its negative impacts by the development of new GHG control technology, carbon neutral equipment, and energy efficiencies. I mentioned here that it will affect industry, but it will also affect all consumers in Quebec. The current government, which was elected on September 4, 2012, has expressed its intention to enhance the objectives of the climate change action plan. The current plan purports to reduce GHG emissions by 20% by year 2020 compared to 1990 baseline emissions. Quebec's plan is designed in accordance with the principles of the Kyoto Protocol, which established its reduction objectives in relation to 1990 emissions. And that's very different from the approaches that were taken several years ago by the federal government, which was calculating reductions from 2000 emissions or year 2004 or 2005 or 2006. Now they're not using that anymore in their calculations. The Quebec National Assembly endorsed officially the Kyoto Protocol by adopting a special motion to this effect, and this motion was adopted unanimously several years ago. It includes actually an array of incentives and mandatory emission reductions. Within the context of its previous climate change action plan, which existed before the current one, Quebec imposes a carbon tax on distributors of fossil fuel since 2007. So right now, all distributors of fossil fuels, that includes gas and all petroleum products and coal, they have to pay a carbon tax. The carbon tax generates annually $220 million, which are used entirely to encourage the development of carbon neutral technologies and energy efficiencies. So all of that money goes into a dedicated fund which is reinvested to achieve better GHG emissions reductions. The action plan resorts to economic mechanisms to regulate GHG emissions instead of using only traditional command and control regulations, which is the usual way that governments regulate throughout the world, especially throughout the industrialized world. Quebec was no exception to this, but now the government is moving more and more towards these economic mechanisms that have been embodied in the Environment Quality Act. In 2009, the National Assembly adopted the legislative framework for a market-based cap-and-trade system by amending its fundamental environmental statute, the Environment Quality Act. The regulation establishing the technical mechanisms of the cap-and-trade system was adopted in final form in last December 2012, and is in force since January 1st of this year. Total emissions of GHGs in Quebec in 1990 were 87.13 million tons, including emissions attributed to energy imported and consumed in Quebec, because as you know, winter consumption is much higher than summer consumption, and sometimes Quebec needs, in fact every winter, Quebec needs to import energy from abroad, from the United States mainly, and perhaps also from neighboring provinces, but mainly from the United States. The 2020 objective under which the action plan was designed is to reduce these emissions by 20%. The objective is going to be 69.7 million tons. The cap-and-trade system itself is targeted on sources of GHG that represent 85% of Quebec's total emissions. The action plan identifies 30 priority actions, many of them targeting unregulated sources of GHGs. So you see the cap-and-trade system is targeted at regulated sources, but there are many actions that are also targeted at other sources of GHGs to achieve the significant reduction of GHG emissions throughout the province. Cap-and-trade system is based on mandatory reporting requirements by all emitters of more than 10,000 metric tons in fact, it's not metric tons, I'm sorry. It's 10,000 tons of GHGs annually. It's metric tons, that's right. In 2009, transportation in Quebec was responsible for 43% of GHG emissions. Industry was responsible for 28%. And residential and commercial sources were responsible for 14% of total GHG emissions. The cap-and-trade system is targeted namely on GHG emissions from transportation, industry, and residential and commercial sources. Other measures of the action plan, including regulations and financial incentives, purport to achieve reductions of GHG emissions from other sources. For example, the action plan provides for investment of public funds to encourage mass transit, the electrification of public transit systems, and also the use of electric cars. Let's look and focus on the cap-and-trade system. In April 2008, Quebec joined the Western Climate Initiative with 12 other U.S. states and Canadian provinces. Out of these 13 jurisdictions, only Quebec and California have decided to establish formally a cap-and-trade system to regulate reductions of greenhouse gas emissions. Quebec and California have established an official linkage between both of their systems, which allows a mutual recognition of carbon credits from each jurisdiction. The cap-and-trade system applies to GHG emissions generated by industrial emitters and by distributors of fossil fuels that emit more than 25,000 metric tons per year. Quebec's cap-and-trade system will thus apply to some 75 to 80 industrial establishments. They will be the essential part of this system that is being put in place right this year. The system will have 3 compliance periods between January 1st of this year and December 31st, 2020. The first compliance period runs from January 1st to December 31, 2014. So we're right now in a 2-year compliance period. For this first compliance period, the system will apply to industry and the use of electricity. The second compliance period will apply also to the distribution of fossil fuels. By the end of 2020, the cap-and-trade system should reduce GHG emissions to 54.74 metric tons. That's out of the 75 establishments which are contemplated and targeted by this system. Other regulations and incentives should reduce emissions from other sources to 14.96 metric tons for a total of 69.70 metric tons. So that is the objective to be achieved by year 2020, 69.7 metric tons for the whole of Quebec. Conservatively, the cap-and-trade system is expected to generate government revenues of $2.7 billion between this year and year 2020. This is how the cap-and-trade system works. First, the minister will establish for each compliance period a ceiling of GHG emissions allowed for each regulated emitter. So you take all those 75 regulated emitters, they're the large emitters, the big companies, the big industries, the aluminum plants, the steel plants, and so on. They are the big emitters that are contemplated here. Each of them will have a ceiling of emissions that will be established. Such ceiling will include the emission reductions that the emitter will be obligated to achieve during the compliance period. So if you have a plant that issues normally in the atmosphere 100,000 metric tons, the government will say, the minister will say, well, your objective will be 85,000 metric tons by a year for these 2 compliance years, which means that establishment and each of these 70 or 80 establishments will have to reduce their emissions by the level or the ceiling established by the minister. Normally, the emitter will reduce its emissions in order to meet its ceiling. The minister will provide free allocations of emission rights to each emitter that will be equivalent to its ceiling of GHG emissions. Government will give free of charge these allocations. But at the end of the compliance period, the emitter is obligated by law to cover its actual emissions of GHG and to surrender to the minister emission rights equivalent to its actual emissions. In other words, to take the example I gave you, if the ceiling is established at 85,000 tons and that the minister has provided allowances for 85,000 tons, and that company actually emitted 90,000 tons, it will have to cover the 5,000 metric tons that it exceeded over its ceiling. So if the actual emissions meet the ceiling, the emitter will surrender to the minister its free emission allocations. But obviously that company will have invested money to reduce its emissions. If the reported and verified emissions are above the ceiling established by the minister, that means the emitter has been unable to reduce its emissions, then this emitter has to surrender to the minister emission rights that are equivalent to the totality of its emissions. To obtain emission rights above its free allocations, an emitter may purchase them from the minister during an auction, because the minister will be selling emission rights at auctions about every semester, every 3 or 4 months per year. Or it may purchase such rights freely on the climatic market from another emitter or from another person holding emission rights. Because on this market, these 75 establishments will be players in the market. But actually, any citizen can also invest in these carbon credits, because carbon credits are commodities that will be freely traded. And any citizen, any company that would like even to speculate or to make money on this market will perhaps be on the market and want to buy and trade emission credits and perhaps make a profit, or perhaps sometimes lose money. Offset credits can also be recognized by the minister from a non-regulated emitter and traded on the market. Offset credits can be generated only by non-regulated emitters. For example, a company which is not part of this list of 75 establishments who voluntarily reduces its emissions according to the protocols established under the regulation, can get an award of offset credits. And these credits, once recognized, can be sold on the climatic market, and that company can be rewarded by making a profit by selling these credits. An emitter who reduces its emissions below its ceiling earns emission credits that can be traded on a market to another emitter or to another registered participant. The management of certain aspects of this system has been delegated to a nonprofit organization known as WCI Inc., which also handles California's cap-and-trade system. The cap-and-trade system will apply to emitters of more than 25,000 metric tons per year and will also be accessible to other participants who will want to participate, as I mentioned, in the climate market and trade GHG emission rights. To participate in the cap-and-trade system, emitters and other participants will have to register in the system, and there are significant registration formalities. There are disclosure obligations concerning full information on corporate and business relationships to ensure that the reliability and the transparency of the system and the operation of a free market. For example, there are limits to the quantity of emission rights that a person may hold to avoid one person who has a lot of money of buying a great number of credits and then being able to establish or influence the price significantly. So there are limits to the quantity of emission rights that any participant in the cap-and-trade system can hold. The revenue generated by the cap-and-trade system will be entirely reinvested in measures designed to reduce GHG emissions and adapt to climate change. So adaptation is part of Quebec's climate change program. An emitter who fails to cover its real emissions with an appropriate number of emission rights commits an offense to the Environment Quality Act and is liable to a minimum fine of $15,000 and a maximum fine of $3 million. Actually, I have to revise these figures because the new regulation that was just enacted establishes that the fine will be equivalent to at least $3,000 per ton of exceedance of the ceilings established by the minister. That there's going to be a hefty price to pay if a company is not able to meet its reduction targets. The new government has expressed its intention to increase the overall reduction effort from 20% to 25% by year 2020. I think that's a very ambitious objective. It's the intention, it's part of the program of the Parti Québécois government, but I think they're going to have a lot of trouble to achieve such an ambitious reduction because we should not forget that industry will have to pay, so they're going to create a detriment to Quebec and industry, and also consumers will have to pay for higher prices. So that's why there's going to be a price to pay if this objective is increased to 25%. And since the whole program was designed and took years to design to achieve 20% reduction, obviously the new government wasn't able to change all of that, all of the architecture of the system, of the program, to increase it by 5%. But that's their stated objective, but it hasn't been legislated or put in a regulation at this time. And because if they ever, or when they plan to do that, there will have to be public hearings and obviously discussions with the regulated community and the potentially affected people. Okay. So just here briefly, the next steps for this year, which demonstrates that this system is really an active system. March of this year, there's going to be a training workshop on auctions of emission rights. April 13-12, that's 2 months from now, there's going to be a pilot auction for all the players in the system. May 1st, 2013, allocation of emission units to regulated emitters. So the free allocations are going to be made in May. some early emission reductions will be recognized. Certain companies that have done early actions, early reduction actions, will have credits, will have earned credits, and there's a mechanism to recognize early action to reduce GHG emissions. August of this year, there's going to be a first full auction of emission rights. November 2013, at the end of this year, second auction of emission rights. So that's my presentation. It gives you an idea of where Quebec is going with respect to climate change. And the main message is that the government's policy is very, very firm on this, and all stakeholders are part of this considerable effort to reduce GHG emissions. Thank you.
Okay, thank you, Jean. So up next is Sophie.
This. I'll just take this one.
Oh, is that
Yeah,
one?
I'll just take this one.
All right.
Kwe, bonjour. Hi. I want to thank the Algonquin people for welcoming us on their territory today for this great conference, and to thank the organizers of this conference for having invited me to present, the PowerPoint. Was it already in there?
Sorry.
No problem. To present a paper entitled Indigenous Peoples and Climate Change Policy, a comparative assessment of Indigenous governance models in Canada. I should say it's not an Indigenous perspective on climate change. I'm not Indigenous myself. It is rather a contribution, and I like to put it into context, that I offer for the publication of this book, edited by Benjamin Richardson from UBC, entitled Local Climate Change Law, Environmental Regulation in Cities and Other Localities. So the rather narrow aim of this contribution is to examine the role and the limits of Indigenous governance institutions in mitigating and adapting to climate change through an assessment and comparison on the one hand of the legal framework governing Indian bands in Canada, and on the other hand, self-government agreement. And I will use the case study of the Nunatsiavut Labrador Inuit self-government agreement as an example. So the paper focuses on the institutional constraint on the capacity of Indigenous communities to address climate change in accordance to their priorities, needs, and values. So in other words, a very narrow question I had to answer is if Indigenous and Indigenous communities want to adopt measures in order to mitigate or to adapt to climate change, do they have the power to do so? Right. So what I'm proposing is a jurisdictional assessment of formal Indigenous governance institutions rather than a qualitative field-based research. So in order to document existing measures, policies, or actions taken by Indigenous communities to tackle climate change, I would have had to do extensive work, which would go way beyond the scope of the paper I'm presenting today. So why is such research, sorry, forgetting about my, everything I said is there, I said it. So why is such research important? Well, first, Indigenous peoples, as many of you already know, are disproportionately affected by the impact of climate change, including the loss and disturbance of biodiversity, sea rise level, and coastal erosion. So why is this disproportionate impact? Well, we can, I mentioned here many factors such as geographical location. Many Indigenous communities, for instance, are located very close to coastal areas. The abject poverty in which a lot of many Indigenous communities live in this country, or the majority of Indigenous communities. The reliance of many Indigenous communities on the natural environment and its resources for their livelihoods and cultural integrity. I can take the example of the Inuit people in northern Canada, on which I did a lot of research, including my PhD, who still depend tremendously on foods from their land in order to ensure their basic nutritional needs, but also as part of their culture. And finally, they're vulnerable because of the marginalization from international and national decision-making processes related to climate and energy law and policies. So why is it important to discuss of Indigenous people's agency in climate change? While I was writing this paper, many people said, well, there's such low producers of greenhouse gas emission. Why focusing on Indigenous communities' policies on reducing climate change? And a lot of people challenged me with that, so I offer the following response. The contribution of Indigenous people to climate policy could be to reframe the issues, first of all. So from a techno-scientific and economic discourse on climate change, we could use a more human rights and Indigenous rights approach to climate change issues. In order to refine our understanding of climate change impact through Indigenous knowledge, experiences, and values. And finally, to design policies, programs, and actions for climate mitigation and adaptation that are tailored to the specific circumstances of the communities that are affected. So in any colonial regime, there's a lot of top-down approaches to many issues that are imposed on Indigenous communities, and climate change can be the same, right? Having top-down solution imposed on Indigenous communities that may not respond to their new circumstances and may actually be very colonial in nature. So increasing Indigenous people agency in climate change decision making would, first of all, uphold the rights that are recognized in international law and also in constitutional law in Canada, and also foster post-colonial and environmental justice. So those of you who came to the environmental justice workshop, we discussed that today already. So I'll pass on the international norms today. To go to the heart of my topic, which will be the governance models in Canada that I want to compare. So first of all, what are the Indigenous governance models in Canada? You may not be familiar with them. Well, there are Indigenous traditional governance systems which may often operate in the shadow of formal Canadian law. The majority of First Nations are also governed by band councils that are organized under the Indian Act. So there are actually 615 Indian bands in Canada, most of them consisting of small communities counting less than 1,000 inhabitants, together occupying a territory of approximately 3.5 million hectares, 35,000 kilometers square. Other Indigenous peoples, including First Nations and Inuit, have concluded self-government agreement with Canada, generally as part of a broader land claim agreement. So since 1995, 19 self-government agreements, including Nunavut, has been concluded with Indigenous peoples from BC, Yukon, the Northwest Territories, and Newfoundland. And finally, there's other forms of political autonomy in Canada. I won't describe them all. I just mentioned here the example of the Nunavik Inuit that are organized basically as in municipal structures called the villages that are akin the other municipalities in Quebec. So this contribution will focus only on two types of government, which are the Indian bands that are organized under the Indian Act and self-government agreements negotiated with Canada. And I'm going to focus more especially on the Nunatsiavut agreement to give you examples of the type of power that Indigenous people can exercise in order to tackle climate change. Starting with Indian bands in Canada. So, as I entitled it, and you will understand with my conclusion, Indigenous Indian bands in Canada have limited capacity to address climate change. So, briefly, for those of you who are not aware or not very familiar with the Indian Act, Indian band councils are the governing structures created by the Indian Act. They are formed of a chief and councillors that are selected generally by elections held every 2 years under the Indian Act, unless they have been permitted by the federal Minister of Aboriginal Affairs to designate their members in conformity with the band customs, but I'm not going to enter into that. The jurisdiction of Indian bands is primarily defined by the Indian Act, and it pertains essentially to local matters. The Indian bands bylaws apply only within the boundaries of the reserve being the land set aside by Canada for the benefit and the use of Indian band. The Indian band bylaws must be consistent with the provision of the Indian Act and all regulations adopted by the federal government under the Act. And finally, I should precise that the Minister of Aboriginal Affairs may, at his own discretion, disallow any ban cancel by law. So in talking about Indian bans and climate change, we need to understand that we are functioning into an essentially colonial regime, right, that is under the supervision of the federal government. So I tried to analyze the powers conferred to Indian bands through that act in order to figure out which ones could be used for tackling climate change. And I had to use sometimes 2 minutes? You're kidding me. Oh my God. Okay. Try to go very, very fast. Well, providing health for residents on reserve, the construction and maintenance of local work, construction, repair, and use of building, the construction and regulation of the use of water supply, zoning, and the preservation, protection, and management of fish and game. So these are formal powers I'm going to discuss. There are some non-regulatory initiatives taken by bands. I'm just mentioning him, the development of wind farms on or off reserve, small-scale production of hydroelectricity or use of solar energy, but I'm not going to enter into that because I have only 2 minutes left. So what are my conclusions from the analysis of those powers? Well, first, that they have band councils have very limited scope to regulate climate change. So Indian bands don't have general power to regulate environment on reserve. It's the federal government that has jurisdiction to regulate the protection of the environment on reserve. And as the Auditor General 2009 report states quite clearly, it's doing a very poor job since it concludes that regulation and implementation and enforcement of environmental norms and policy on reserve is highly problematic. The Minister of Aboriginal Affairs can disallow any band council bylaws, as I said, which could include, for instance, bylaws that would impose more costly obligation, including like imposing certain types of materials or design of buildings in order to make them more adaptable to shifting environmental conditions. The territorial scope of Indian bands is also an important limit on their jurisdiction, since they can only exercise it on reserve. Reserve lands are very small, 2% of Canadian area, and the courts have enforced those limits quite strictly. So in a case, R versus Lewis, 1996, the Supreme Court decided that an Indian band's fishing bylaw was not applicable to fishing activities exercised by band members in waters immediately adjacent to the reserve. So we can imagine that the capacity of Indigenous bands, of Indian bands to regulate fishing and hunting in order to adapt to climate change might be thwarted by the fact that their regulation cannot apply out of reserve. The 2-year electoral cycle has been identified as an impediment to regulate climate change, since it does not permit long-term planning. And I will just mention here the lack of material and technical resources and the myriad of other pressing needs over reserve is probably one of the most important limits on Indian bands to be able to adapt measures to tackle climate change. There's an act, I'm not going to discuss it today. The First Nations Land Management Act. Just have to know that it's a possibility. It's an act that actually brought into law an agreement that was concluded by 14 First Nations and Canada. It permits, following the adoption of a land code in conformity with the law, for the band to have an extensive jurisdiction over land management, and also some legislative powers that include the power to legislate on the environment, and that would be broad enough to legislate over climate change. We have to know, however, I'm going super fast, I'm sorry, I'm lacking time, that there's only 69 nations so far that have signed into the framework, which is depends very on the vagaries of federal funding. So the federal decided to cut its funding in 2009, reestablished it partially in 2011, but so far we cannot say that this act has played an important role in Canada since only a few First Nations have actually adopted such land codes and have law powers over their own environment. This contrasts tremendously with the type of powers that some Indigenous people have been able to negotiate with Canada through self-government agreements. And I don't want to say that those agreements are perfect, they're perfectible, but you can see very important differences from the Indigenous capacity to tackle climate change for those agreements compared to under the Indian Act. So very briefly, since 1995, 19 self-government agreements, including Nunavut, has been concluded. All northern Canada is covered by Lakeland's agreement and self-government agreements. So each of those agreements contains specificities that I will not talk about today. So I'm going to focus exclusively on the Labrador, the Nunatsiavut Inuit Land Claims Agreement that was concluded in 2005 between the Nunatsiavut Inuit, Labrador, Newfoundland, and Canada over the Labrador Peninsula you see on here on the map. So the Chapter 17 of this agreement is creating the Labrador Inuit self-government. This self-government contains two levels, a regional government and 5 community local governments, and also an Inuit court. So there's a judicial system that has been created in order to enforce and implement Inuit laws. So which powers can be used by the Nunatsiavut government to address climate change? Well, at the regional level, the government has a general jurisdiction over the protection of the environment on Labrador Inuit lands, which covers 15,800 kilometers square. In accordance with this power, the Nunatsiavut government has adopted the Nunatsiavut Environmental Protection Act in 2012. Although it does not address climate change directly, it provides regulatory powers that would permit the Nunatsiavut Inuit to, among other subjects, to establish emission limits and to reduce climate change impact in Nunatsiavut. The regional government has also power over the administration, control, and management of Inuit-owned lands, on the exercise of Inuit wildlife harvesting rights, and on Inuit education and health. The federal and provincial governments do have paramount say on certain subjects. I'm not going to cover that. It's a very complicated issue, but I could discuss it later. To these powers, we have to add the local government powers, which have the jurisdiction over management, administration, and disposition of community lands, water protection, prevention and remediation of erosion, zoning, regulation of building. And all those powers can be used in order to tackle climate change. We can think about regulation of buildings, for instance, that can be used to adopt green measures for building green codes for future buildings on Nunatsiavut land. Zoning can be used in order to prevent construction in flooding zones, for instance, or to reduce, or in zones that are subject to erosion, and so on. The Inuit people have also adopted, well, the Nunatsiavut Inuit has adopted the Nunatsiavut Constitution. Okay, I'm going to conclude very quickly. So every Labrador Inuit could invoke its right to a clean environment against the Nunatsiavut regional government or the Nunatsiavut local governments if they think that an action by those governments is infringing upon their environmental rights, including in regard to climate change. And finally, just a word about customary law. So you have laws adopted by the regional government, local governments that could take climate change action, but it could also be supplemented by customary law, which is recognized as the underlying law of the Labrador Inuit and the Nunatsiavut, and that actually has precedence over the laws adopted by the Nunatsiavut regional government or the local government, unless the law explicitly say that it wants to derogate to customary law. So customary law is the common law of the Nunatsiavut land, and indeed in customary law that can address climate change related issues could play an important role, but in order to know that role, it would be necessary to conduce extensive field work in Nunatsiavut, since these customs are not codified. And finally, there's co-management institutions that have broad powers to participate in the governance of water, ocean, and land in the region of Nunatsiavut, and that may complement the limits that are imposed on the territory where the jurisdiction of the Nunatsiavut Inuit apply. So, there's also some limits, and the material and technical resources, as well as for the Indian bands, are an important limit to the capacity of the Nunatsiavut government to adopt climate change action. So this will take me, since my time has gone, to just very general conclusion to which I come to this paper. It's a very detailed paper, so I went very, very fast with all that is said there. But in general, my first conclusion will be that alleviation of poverty is the first. If we want Indigenous people to tackle climate change, should be our first priority. So you can have a very broad jurisdiction, but when you have a dire housing crisis, food crisis, health crisis in the communities that they have now, climate change may not seem like the priority at the moment. Widening Indigenous people's jurisdiction over environmental protection, especially for Indian bands on reserve, is really key. Increasing Indigenous people's agency in climate negotiation processes at the national and international level. This is a climate justice issue, that Indigenous peoples are generally marginalized from any decision-making processes meant to tackle climate change, or if they are present, they participate, but I wouldn't say that they have agency in the sense of being able to make change in the outcome of decision-making, and this is really key. Increasing funding and technical assistance for actions directed at mitigating and adapting to climate change. And finally, tailoring climate change in Indigenous policies and programs, including in the negotiations of factoring climate change in Indigenous policies and programs. Included in the negotiation of land claim would simply mean that if we are to have housing programs on reserve, for instance, why not factor in climate change right now instead of having to rebuild buildings down the road, 20 years down the road, 50 years down the road, because they would not have been adapted to the shifting environmental conditions. So these are basically my thoughts, and thank you.
Okay, so we're right at 4 o'clock. Jean has to catch a plane, so I don't want to hold you up. Do you have time for a question?
5 minutes.
Okay, all right. So let's do a couple quick questions, if there are any.
Yeah, hi. I just have 2 questions, so I'll address Maître Piette first, since you have to leave. I'm just wondering what you think about what lessons can be drawn from the Quebec Climate Change Action Plan for other provinces, given that looking across Canada, there are such different energy mixes, and when you look at Quebec, we have a relative luxury of having a lot of hydro, which is basically emissions-free.
What I could say, first, when you have a political will to move in a given direction to improve the environment, things can be accomplished. And it is a fact that the previous Liberal government, which was not necessarily environmentally inclined as such, nonetheless found that it should be a good thing to do, a proper thing to do, and it got considerable support to achieve this policy. Now, Quebec is in a special situation. Indeed, most of its electricity, about 95 or 97%, is derived from hydro. Won't be any more nuclear now, as you know. So Quebec is in a special situation where transportation accounts for 43% of its total GHG emissions. So it has to focus on all these transportation sources, and it's a challenge of its own to try to do that. Other jurisdictions have other sources, like, for example, thermal power plants or other sources, other industrial sources. So each province has to design a plan that will correspond to the specifics of its own climate change and industrial structure. So Quebec has made a commitment to move in that direction, has established a clear objective, and has designed a program to try to achieve that with the state of California, because California is engaged in the same kind of effort right now.
Thank you.
Okay.
And I also had a question for Travis. So, this is just regarding the floods part of your talk. So I definitely agree that climate change projections have to be incorporated in municipal and other decision making, and hopefully this will eventually trickle up to the courts. But I'm wondering how you propose courts in particular might deal with the scientific uncertainty that's inherent to projections, which are typically given in terms like likely to occur, and with probabilities and percentages?
So that's a great question, and you're asking exactly the right question, and it's a question that we're currently grappling with. I can't give you a straightforward answer because we don't have any judicial guidance on this front. But what I would tell you is that it's important to, first of all, separate scientific uncertainty in terms of linking a particular event to climate change, which is something that we've had to talk about for many, many different years. And then scientific uncertainty relating to projections that are made by climatologists, flood modelers, people who are talking about permafrost degradation in the Arctic. Because when we're talking about the latter issue, there's always going to be uncertainty. So even saying that we're going to rely on the 100-year flood, for example, is inherently an assumption where we're making an assumption that what happened before is going to be the same as what's going to happen tomorrow. So I think that in that sense, we always have to deal with that issue. And my recommendation, and one that I've made to people at NRCan and to municipalities across Canada, is that we need to actually get together and discuss this between lawyers and engineers and municipal decision makers. Because we can't solve this problem on our own. And NRCan has started doing some of that work, but we need to do more. So great question. I hope you will engage with it as well.
Okay, is that everything? So let's extend a thank you to our panelists.